Bienvenue Saint-Lucie pour l'autre session CAI Sénat là. Ça c'est deuxième ça nous garde niveau ça qui est passé en CAI Constit puisque Parlement a deux niveaux. Ça c'est niveau côté c'est ça nous garde CAI Constit côté c'est membre Parlement qui électé. Avec l'autre niveau, c'est l'autre côté, c'est même Parlement qui est sélecté, c'est nous qui est sélecté sur Sénat là. Il y a 4 sessions aujourd'hui, c'est directement après session hier qui était comme Constit. Avec moi ici et puis Virgile Léonticon pour la coutume. Virgile, bienvenue.
Thank you, Michael, and good morning to all our viewers. And welcome again. As Michael said, today is the sitting of the Senate. And how did you describe the chamber? What is the chamber? What is the name for chambers in Patois?
Different levels.
Oh, different levels. Yes. Okay, so here we are at what we call the upper house.
That's
and
right.
It consists of representatives that were selected, not elected, by the different political parties, the government and the opposition. And we have independent senators. And we are about to start as we see the sergeant making his way with the mace. This signals the commencement of the Senate hearing for today, Tuesday, October 17th, 2024.
Let us pray. Almighty God, by whom alone kings reign and princes decree justice, and from whom alone cometh all counsel, wisdom, and understanding. We, thine unworthy servants, here gathered together in thy name, do most humbly beseech thee to send down thy heavenly wisdom from above, to direct and guide us all in our consultations. And grant that we have in thy fear always before our eyes, and laying aside all private interests, prejudices, and partial affections, the result of all our counsels may be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the King, the public weal, peace, and tranquility of St. Lucia, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen. The grace of the Lord Jesus Christ and the love of God and the fellowship of the Holy Ghost be with us all evermore. Amen.
Announcements. Good morning, Senators. I have received correspondence from the Speaker of the House of Assembly advising that the following bills were passed in the House of Assembly and forwarded to the Senate for its concurrence. Insolvency, Julian Alfred D. I have received excuses from Senator Egelina Polius, who is unable to attend today's sitting. Senators, at our last sitting, I had informed that St. Lucia's representative to the Miss Universe pageant had requested a few minutes to engage with us briefly in our capacity as members of the ICCF. Because of our interest in the area of sustainable development and climate change, we are hoping to meet her today during the lunch break for a brief conversation. And before final announcement, I want to thank those of you who are here, Senators. I know the weather, inclement weather, from your neck of the woods, so you made the effort, especially those of you coming from beyond the Bad Lil, and of course, Soufrière. Very good of you to put the people's business at the top of the priority list. Senators, at the last sitting of Parliament on September 11, 2024, unparliamentary language was used by Senator Dominic Fady, who was not on his feet at the time. I want to draw Senators' attention to Erskine May parliamentary practice wherein it states at paragraph 21.44, and I quote, "Where any disorderly or unparliamentary words are used, whether by a member who is addressing the House or by a member who is present during a debate, the Speaker, presiding officer, will intervene and call upon the offending member to withdraw the words. If the member does not explain the sense in which the words were used so as to remove the objection of their being disorderly, or retract the offensive expressions, or make a sufficient apology for using them, the Speaker, presiding officer, will repeat the call for the words to be withdrawn and inform the member that if there is no immediate response, it will be the duty of the chair to take action in pursuance of the standing orders," unquote. The standing orders are our written rules which regulate the proceedings. The written rules are permanent. They do not lapse and remain until amendments are made. The Senate's standing orders came into effect on the 15th day of May, 1979, with very few amendments over the years, so the rules are not new to us. Members, let us respect the rules of Parliament as they allow for the efficient operation of our Parliament. If we do not adhere to the rules, we will bring our Parliament into disrepute, and I shall not allow it in the Senate while I preside. I shall be guided by the standing orders to ensure that order is maintained in the Senate at all times. I look forward to the cooperation of all senators. Statements from parliamentary secretaries, ministers. Papers to be laid. Honorable Leader of Government Business.
Thank you, Madam President. Good morning, colleagues. Madam President, I wish to lay the following papers standing in my name. Statutory Instrument Number 108 of 2024, Health and Citizen Security Levy, Variation of Levy Order. Statutory Instrument Number 123 of 2024, Stamp Duty, Amendment of Schedule Number 2, Regulations. Statutory Instrument Number 124 of 2024, Price Control Amendment Number 13, Order. Statutory Instrument Number 125 of 2024, Excise Tax Amendment of Schedule 1, Number 13, Order.
Bills. Honorable Leader of Government Business.
Madam President, I beg to present for second reading a bill shortly entitled Insolvency. Just to get a Thank you, Sarge. Madam President, I beg to move for a second reading a bill shortly entitled Insolvency. Madam President, we have had a similar situation where in the last sitting, for example, we came to this Honorable House, or Honorable Senate, to present a bill that had been in the public domain in circulation for over a decade. This bill carries a similar character in that it has been, or it has spanned more than 2 different administrations I understand, under 3 or 4 different prime ministers. There had been quite a lot of extensive public consultation and consultation with other stakeholders, which clearly tells us that this is a very significant bill, and for it to be part of our Senate today and, of course, passed in the lower house yesterday, tells us that it is a very important step that we believe needs to be taken in the interest of both creditors and borrowers or consumers in this country. The general intention of this bill, Madam President, is to allow for creditors and borrowers, or debtors if you like, to come together to try to work out, or to dialogue to work out difficulties that the debtor or the consumer may encounter when it comes to meeting the obligations or whatever arrangements they would have had to pay off loans or debt that they have taken. Madam President, this is proposed to be done in the form of what we call a consumer proposal. And that intention is the spirit within which I would like to explain the context or the intent of that bill. It is a very thick document. If you check the size, the mere size of the document, Madam President, and 274 pages. And I am thankful that I am not a lawyer, because I can imagine not only having to read, but to interpret, to analyze, to edit, and to get that document to become a legal document to be passed, would require a substantive amount of work. And so in that vein, I would like to thank the AG's department and his staff, as well as all of us who have been part of that effort to get this document to be tabled here. Madam President, this bill is intended to help to bring some kind of fair and balanced opportunity to both sides of the table, if you like. In any main loan transaction, you have two sides: the person who borrows and the person who is lending. And most times, if we have to look at the previous legislation, the party who is borrowing would have appeared to be the one that was suffering the major consequence should that party falter. Now, while, Madam President, it is true that we have some delinquent borrowers or debtors or consumers who do not genuinely honor their commitment to pay their bills or to pay their loans. Sometimes I think we refer to some of them in the Creole Palace as mauvais paye. You know, they borrow and they don't want to pay. That may be so. However, Madam President, there are people or circumstances where the party who has borrowed encounters genuine difficulty. That may include unforeseen circumstances, illnesses, and as we saw, when there are natural disasters, people who are dependent on their daily proceeds to make money, their livelihoods are interrupted with situations that they did not call upon themselves. And they may be unable to meet commitments for a period of time, but are willing, very willing, to deal with it. These bills allow for such opportunity. And these opportunities will allow the person who owes, or the party who owes, and the party who is owed to come together and say, you know what, we can work this out. Madam President, that is what the consumer proposal refers to. And so it is important that we recognize the benefit to both the person who's borrowing and the person who is lending. Because some may want to believe that, well, why do you want to give consumers who are delinquent an opportunity to get away? That's not what this bill's intention is to do. It also gives the person who has their money out there, or the party who has their money out there, whether it's the bank or the credit union, to have an opportunity, instead of having to seize someone's primary dwelling house, or what we call a homestead, to be able to have an opportunity to make the commitment. This bill has been lying around, Madam President, since 2014. And it is important for us to appreciate the need for us to come here today and get it through so that that particular opportunity can be created. In fact, the opposition has also admitted that it was their intention to pass the bill, and they also admitted, and which was good to hear, that they see the benefit in the advantage to both the creditors and the borrowers, and that was in the previous debate. So, Madam President, I have attempted to just make it clear that there is a reason and there's a context to us being here. You will notice, Madam President, throughout this discussion that there will be a number of amendments that we'll have to make to allow for a number of things to happen. And one of them refers to making it less practical or not as easy for a man or a woman raising his family in their dwelling house to have that taken away from them because they faltered. Particularly in a case where that dwelling house has a value of $400,000 or less. And on page 42 of the bill, that is referred to as the opportunity to have the consumer proposal to address the repayment. Madam President, in that particular clause, under Section 27, the bill proposes, and if we go to that on page 67, we'll notice that the bill proposes to allow a trustee to act on behalf of the person in debt, and also proposes to extend the period that the person in debt has to be able to reach out to the bank or to the institution to propose that arrangement. In the previous bill, or it was a period of 10 days, and it is proposed to extend that period to 21. And I think even in the last sitting, I think it was changed to 30. Madam President, there are instances where the person who is in debt or the debtor, like I mentioned earlier, may encounter a difficulty. So by way of example, a terminal illness, a medical situation, a situation that may have drained or may be draining them of their savings. They may have, let's take a nurse, for example, with a salary of $3,500 a month. Her mortgage payment is $1,500, $2,000 with her partner. And she finds out that her partner has developed a terminal illness. The bills have to be paid. The commitments have to be met. And it chips away from not only her savings, but her ability to make those payments. And Madam President, I'm sure any good husband, wife, child, parent with a situation will have to prioritize. You may have to decide whether you spend what you have on a family member who is terminally ill to save their life, or to allow the bank to, take away or have your property seized. This bill gives that person a window of opportunity to address that. And so it proposes that instead of 6 months within which that can be negotiated, that the period be extended to 1 year, which of course allows for more time for both parties to put in a plan to manage. Madam President, there is also an opportunity for the debtor, in that case, the bank or whichever financial institution, who would normally have seized your property and auction it and sell it for whatever price they want, and you get nothing. So you may have owed a bank $200,000, you have paid 100, or you have paid 60. They seize your house, and they sell it and you get nothing. Madam President, quand calculer ça, on monsieur et madame, et puis Marie, yo fait caillou, yo prend un loan pour $200,000, yo a payé 60,000, et puis yon a dans yo malade, yo passe à payer banque là aller, et puis banque là point caille là, saisi caille là, et puis vendre caille là ba l'autre monde délai pour moins passer ça yo doya. Et moun là qui perd caille pas ça trouver rien pour ça peut-être commencer en l'autre côté. That bill, Madam President, allows in sections 173, and that would be on pages 132 to 134. It allows for the consumer or the debtor to receive a percentage from the proceeds of sale from the value of the property, as opposed to what obtained before, where you lose everything entirely. So it means, therefore, that you will probably have an opportunity to get something back so that you can start somewhere. Peut-être soutenir kay 3 chambres et puis on y a un petit caca ou ça faire une chambre et bien 2 chambres à côté, même si il y a une manière pour ça faire pour pas les chimères. Madam President, this whole process has taken quite a lot of time and consultation, including the National Competitiveness and Productivity Council, the NCPC, and we accept that there will be need for quite a lot of public consultation on that particular bill. Now, as I said when I started, Madam President, it's a very thick document, and there is a lot of information that can be shared. I can stay here for the next hour to give you and to cite a number of different examples that can be used to justify why this bill is important. And there are some technical areas as well that would have caused the AG, for example, to handle this in the lower chamber. And that is one of the reasons why I took the approach of putting it in context and explaining its purpose, rather than going into all the various clauses one by one. But when we make the amendments, Madam President, at committee stage, some of these clauses that we will adjust or we will amend will explain why this bill has come before us. And why is it beneficial? As I said to both parties, the consumer has an opportunity not to have his or her credit rating affected so badly, and the lender is able to collect something from the value of what was owed to them. So their relationship is protected. Madam President, the clauses that I refer to, by just way of example, there are a number of amendments, but I just want to cite a couple of them and why these amendments need to be made. And so if we just by a cursory glance, we have made amendments to the process by which the administrator is appointed, as well as in Part 62, how the trustees are appointed, the way the creditors are notified in Clause 2.8, as well as the way in which the process is gazetted. And all of these are examples of adjustments that are going to be made to make this bill more balanced and fair to both the consumer and the borrower. So, Madam President, I believe that it is critical at this time for us to help facilitate that process on behalf of our average St. Lucian, who is not a delinquent person, because if you're delinquent, the bill almost also makes provisions for there to be a process to cause you to have to take responsibility. Because if you, after all of this is done, that a consumer still is not honoring, and the Madam President, konodi, si ou ka di an moun, Bakla nous ka mette morceau loi salala pour bakla pas ça en ek vini point kayo. Et nous ka dit OK, nous ka ba ou en l'année pour ça 6 ek banque là et puis garder une manière pour ça payer. Et si après vous faites tout ça, nous ka juste dit si vous doit banque là kaila là pour saisir. Plutôt banque là point kaila et puis vendre li et pas jouer dans rien. Banque là kay ba ou un ticket choy à sous ça valet propriété aille. Bon si tout ça fait et puis ou pas qu'à faire effort abodi abofes. Là supposé ni en manière pour ni banque là et ben credit union là et puis ni moun là qui doit banque là pour la ni en manière pour yon moun pas perdre. So Madam President, the bill also addresses that because at that stage the trustee can be appointed to allow to facilitate a fair outcome. And so I believe that the general spirit within which this bill is presented is very positive, and I think its intent is to facilitate some measure of some opportunity for people not to lose their dwelling house where they raise their families, but also to protect the lender so that delinquent clients don't just feel that they can not honor their commitment and turn their backs. And so, Madam President, within that spirit, I wish to ask the support of the Senate so that this piece of legislation can be passed and with the amendments to facilitate the intention for which it was brought to this table. I thank you, Madam President.
Senators, the question is that the insolvency bill be read a second time. Senator Charles.
Madame Président, l'année à mon créole, il a dit, on va pas ni pardon devant poule. I'm sure Senator Gideon has heard this, and most of us coming from rural communities or having grown up in yards would understand what I'm talking about. But for those who are uninitiated in the Creole proverbs and tradition, literally it means roaches have no chances before the fowl. Figuratively, it speaks about a power imbalance between the cockroach and the fowl. And imagine you have a yard which is very wide. The cockroach could fly around anywhere it wants, but it couldn't escape that beak of that fowl. I started with this proverb just to illustrate historically the relationship debtors have had with financial institutions. And this Wavet devant poule scenario sometimes results in a psyche of fear of our people when they approach financial institutions, because they know that these institutions have the power, whether they have the power of their money, they have the power of institutions behind them, and they have the power historically to make decisions which start off in an imbalanced situation. So when you take a loan from a financial institution, you almost live in fear, because you know if you default, as the senator has said, you lose your house, you lose whatever you have worked for. And my mother always used to tell us, "Pas jamais doué moun." In this day and age, it's difficult not to owe, because for you to invest and to grow, you don't have all the financial resources available to you immediately, so you have to take a loan. And this piece of legislation, which is before us today, is really, really important in trying to resolve this imbalance between the consumer and the service provider. However, one of my concerns, Madam President, is that in trying to resolve the problems, you still have sometimes to go to the courts. And again, the situation of going to court for poor people is again, pani pardon devant poule. If you do not have the means, because it's litigation, you do not have the means to employ very good lawyers, do your own research, come up with your evidence, then it results in the same situation, having to forfeit your property you have worked for so long. Notwithstanding this, however, I think it is very, very important that this solution is available for us as a society. I noted that in the lead up to the debates, there was lots of PSAs, public education, on this insolvency legislation, which is very good. However, we must bear in mind, when you get to a situation of insolvency, there has to be a certain element of responsibility on both parts. Because most times when financial institutions just give loans, there isn't the continuous engagement with the clients to ensure that the client can meet the obligations. It happens sometimes. I mean, some institutions, particularly credit unions, are very good at that. But then you just left on your own to fare for yourself. Something comes up, then you find yourself in dire straits, you can't pay your loan, and then you have to forfeit your property. So I think going forward, in addressing that situation, the framers of the legislation have to bear in mind that information is particularly important for people. Being aware of the situation that you're getting into, what we call in advertising, reading the fine print. Because most times this is where we get stuck. Not being able to read the fine print for many reasons. It's either too fine to read, or sometimes it's in a language that you can't even understand. So I think there's a tremendous responsibility on us as legislators to ensure that financial institutions convey information in a manner that people can understand clearly. And perhaps, Madam President and Leader of Government Business, in the development of regulations to support the primary legislation, that we have to pay attention to information. There is a concept in regulation called information symmetry, which means all parties must have access to the same information and the same interpretation of the information so they can make informed decisions. There's always information asymmetry in the scenario that we're speaking about. Because as the Senator spoke, this document, many people don't understand the language in which it's written. This creates an information of asymmetry. And hence the reason why we have to assist consumers as best as possible to understand the provisions of the Act. And in doing so, I would strongly recommend that, again, at the stage of regulations, that we sort of factor in provisions to ensure frequent reporting on the administration of this legislation. And it has essentially 4 principal benefits. 1, this would build confidence in the system. If people know that after a year or so, you have had cases, the cases have been resolved, and you can actually read the cases, we know it's working. Secondly, it gives you an opportunity to analyze and assess the institutions which are involved in the regulation. I note in the legislation that it will be reviewed no more than 5 years. I think it's 5-year intervals for review of the legislation or of the operation of the legislation. I find 5 years for the nature of the situation you're dealing with is long, but it says not more than 5 years. So I'm hoping it will be probably annually or every year. And the data that we get will give us an opportunity to review. The third important point, Madam President, is reporting is one of the fundamental bases of accountability. If you don't report, we don't know what's happening. And I would even go further to suggest that that reporting reach the level of the Parliament. I didn't see, maybe I missed it, provision for the tabling of the report of the supervisor. I think that's the supervisor of bankruptcy. And like most regulators, I think provision have to be made for annual reporting. So when you get back, you get that information, it can be reviewed so we know whether we're on the right track or not. Because there may be lots of unintended consequences of legislation which we are not sure about. And I want to go back just briefly, Madam President, I won't be very long, to the question of information. In our society, companies and institutions are free to advertise as they wish. Most times advertisements are misleading. They give you information that sometimes are not based on fact, but they're there to sell a product. And people make decisions based on that information, and hence sometimes get into problems. So we may have to consider, as maybe down the road, another piece of legislation, or again in the regulations, some provision to be made on addressing the information that goes out to the potential consumers and purchasers of information services and loans, for instance. What I think is good, like again to use another Creole phrase, what is good for the goose is good for the gander. In Creole we say, Saki bop mati we, I bop mati win. Madam President, I think this insolvency legislation is something that is been long awaited by a lot of our consumers. The fact that it took 10 years to come to this chamber is not so much of a big issue, but I think we have to bear in mind that we keep abreast with the changes, and the changes are factored into the current version. And just a small point on the publishing of information. We continue to make reference to publishing information in the Gazette. I think it's about time that we consider there are modern platforms for publishing of information that can reach people much quicker than the Gazette. And it's just for consideration in upcoming legislation. Government has a website. This website can become one of the mechanisms for publication of notices and information, so at least it can reach people much quicker. Madam President, Senators, these are just my few remarks on the insolvency bill, and it's a document I will support wholeheartedly. Thank you.
Senator Stanislaus.
Thank you, Madam President. I rise to say a few words, make a contribution on this bill, which was presented by the leader of government business, Madam President. A very voluminous piece of legislation, Madam President, as he articulated earlier on, with I think over 270 pages, but also a piece of legislation I believe is also very consequential to many, many persons in this country, Madam President. This is a bill, Madam President, I am familiar with, not in its current state, as he said that it has been around for over 10 years, and there have been many drafts of this legislation. But I remember clearly in either sometime 2018 or 2019, there was a presentation made to the cabinet by the AG's Chambers and Ministry of Finance on this Insolvency Act. But a lot of changes have been made since then, Madam President. And after that presentation was made and the parties left the cabinet room, it so happened that myself and the member for Choiseul was sitting opposite, uttered the same words to the then AG about this legislation, and we both said to the AG, Mr. AG, we believe that this piece of legislation should sit on a shelf and pick up dust for some time because of the consequences of many of what was presented to us at the time, Madam President. I still believe, Madam President, that this is not the opportune time for us to have this bill presented. With all the goods and the bads in it, I still believe that it is very, very consequential, and I'm going to get to that very shortly, Madam President. The leader of government business in his presentation, Madam President, spoke about the positives to both the creditor and the debtor, which I understand very clearly, in the creditor being able to recover their monies or their assets and so on, as well as debtors being able, if the asset is seized or foreclosed, if you want to say, they're able to get a little something out of the sale to start over. But the essence of this bill, this piece of legislation, Madam President, is very simple, that it is now going to be much, much easier for the banks to come after the properties of people, for the banks to seize the properties of people. And I'm going to come to that, Madam President, to explain why I'm saying it is going to be much easier. The bill also gives provision where, Madam President, that, of course, persons who are going through financial issues and so on, and they want to do debt consolidation or amalgamation, they're able to do so and put their finances in better positions. But I want to go to what obtains now, Madam President, when I say that it gives the banks more leverage and easier access to seize, to confiscate your property under our existing legislation, not this Insolvency Act. And permit me, Madam President, to just go through a summary of what currently exists in our legal system in protecting consumers against the jaws of those sharks out there with the banks. I call them sharks. Because this legislation, Madam President, this is a legislation that regional, international financial institutions have been after the government of St. Lucia for over a decade to bring forward. It is something that is being forced down on us because many other islands in the OECS in CARICOM, they've adopted it. St. Lucia, I believe, was probably one or two other countries without an Insolvency Act. So let me just go through, Madam President, just to give you a summary of what currently exists. First, a letter from the bank in respect of outstanding payments is sent to the, and this is from my research, Madam President, with legal minds and persons in recoveries, securities at the banks, and I just put a summary of my conversations with them on what currently exists. Beg your pardon?
I'm saying this is your research.
Yeah,
I was going to ask you to put where you...
research, okay. Yes, yes. Indeed, I will not mention their names, legal minds and certain persons I spoke to. I just wrote it and I'm just giving a summary of what currently exists.
You are going to share with us what you found out.
Yes, what I found out.
Okay, I prefer these terms.
Yes. Yeah. What I found out. Yeah? Okay. A letter from the bank, first a letter from the bank in respect of outstanding payments is sent to the person owing on the mortgage, requiring the person to come into the bank for a discussion on the outstanding amount and why it is not being paid. If the person comes in, the supervisor has a discussion with the person and the bank may refinance the loan or make some kind of arrangement for payment to the satisfaction of the bank. If the person owing on the mortgage ignores the bank's invitation to come in and discuss the situation, then the bank will engage its lawyer to file a claim against the person owing. That's the first step. Next, St. Lucia's law is different from other islands where the banks can more or less ask you to hand over the keys in default of payment. Under our law, when you take a mortgage, the interest in the land or the property does not shift to the bank. That is very important under our current law. You remain the full owner of the land or the property. What the bank has against your property is a charge of the amount that you take against that property. And it is for that reason, Madam President, that we are not like other jurisdictions where the bank can simply ask you to hand over the keys and proceed to sell your property to the highest bidder. So their charge is against the sum which you take, but not against the property itself. With this legislation, it is going to be different. That is why it's going to be much easier for them to come after your property. Our process, Madam President, requires that the bank obtain a judgment, which in itself can be a lengthy process. Filing of claim, judgment in default, adjournments, etc. And upon obtaining judgment, if the judgment is not settled, seize the property under the law and cause it to be sold at auction. And the truth is, Madam President, an auction can be halted up to the day that it is set if you settle the debt. So importantly, the interest in the land does not pass to the bank. They do not have authority to deal with it until they obtain a judicial hypothec, a judgment. And that is the foundation of why there is this process in place to protect the consumer. To change this process, you do now have to change the law regarding how hypothecs or mortgages are held in St. Lucia. These proceedings, in conclusion, Madam President, these proceedings can take months or years, depending on how cooperative the parties are, the creditor and the debtor. Judges send the parties to negotiate, sometimes more than once or twice before they make a decision. In the decision process, judges will take into consideration all the facts of the debtor's circumstances and ability to pay, and will hand down a decision that reflects the debtor's circumstances and ability to pay. So basically, Madam President, this is a synopsis of what currently exists under our current legal system when it comes to mortgages with financial institutions and debtors. It is a process that could protect them for months, for years, because of the way it is set up, because the banks do not have any form of interest over the property, but over the sum. So they're able to negotiate and so on. But with this legislation, Madam President, it is different. It is different. And we know there are many persons who are very, very vulnerable right now. We have persons who have not recovered. What's that?
Keep focus. Keep focus.
I'm saying, Madam President.
Madam President, I rise on a point of elucidation.
Are you prepared to yield, Senator Stanislas?
Yes. Just to to ask of the member, because he has given us a synopsis, which I accept as his own research. He was honest and did not quote it as fact. But based on what he has said thus far, which I followed, I was wondering from his synopsis whether he is saying that what currently exists, which clearly is at the disadvantage of the borrower, that what we did here has made it any worse than what he just read. And so I would hope that he will elucidate on that.
Yeah, well, that's the point. Yes,
Well, what you have, they have not made it worse, Mr. Leader of Government Business. It has made it easier for the borrower to come and seize the property. This current system, the lender, thank you, Madam Senator, the lender. This current, this existing legislation could take months and even years for the lender to acquire the property. The court system in this current system which we have protects the borrowers a lot more than in this legislation. That's what I'm trying to say.
Madam President.
Madam President.
That's an opinion. Yes, Senator Jean.
Yeah, Madam President, on a point of clarification.
Elucidation.
Elucidation. Are you yielding again? And your light off, please.
Oh, sorry.
Your mic.
Yeah.
Yes.
The member is presenting information without a source, but indicated that it is the law, the current law. That's my understanding. Can you allow
Stop. Could you stop?
the
Stop.
presiding officer to...
Senator Fady. Senator Fady, before you came in, I read an announcement pertaining to behavior in the Senate. You were not there to hear, but I'm reminding you that I expect your behavior to be in keeping with the standing orders. Senator Jean is on her feet, and I need an opportunity to hear her in silence.
Very well, very well.
Please proceed, Senator Jean.
Yes, Madam President. I'm seeking clarification because the member has presented information without a source, but then indicate that this is the prevailing situation according to the law. So if it is the law, then I believe the source, whichever law that is being cited, ought to be disclosed. Because I'm looking at the current Banking Act, and it is not reflective of what the member is presenting. So I just need that clarification in order that we could be clear whether this is simply procedure of an institution or whether it is a prevailing law that is supposed to be used to guide all such transactions. Thank you.
Very well, Senator Jean. Do you care to elucidate, Senator Stanislas?
Yes, Madam President. Like I said earlier, Madam President, it is research which I made in speaking with legal minds and persons in the banking sector.
Yes,
and I think
you did indicate that.
Yes,
however, Senator Jean's question is saying that you quoted a few things and you said it's a law, which you did.
Okay.
So she's asking whether you can quote which part of the law that you were referring to.
Yes.
But we took the point that you did your research.
I understand, Madam President. I can always
minds.
get that for her. But I believe it might be the procedure or the process in which claimants can fight the lenders through that court system to protect the properties from seizure immediately and so on. But I will find the information and of course be happy to hand it over to Madam Senator, Madam President. Yeah? Okay. Thank you, Madam President. As I was saying, Madam President, I believe this legislation could have consequences to a lot of persons, especially knowing that during the COVID crisis, many persons were given moratorium on mortgages, on their loans, and so on. And up to this day, many persons have not been able to clear those arrears and some of those backlogs and so on they had, and this could have dire consequences if they are not able to keep up and able to negotiate and speak with those lenders to protect the property and the assets. The leader of government business, Madam President, also said that in the event, I think you said of terminal illness, Mr. Leader of government business, that there is a 6-month and I think up to a year is given for discussions, negotiations, and so on. But I am not sure if that is going to be sufficient time, especially if persons are terminally ill or persons single breadwinners in households suffer stroke, massive strokes, or some life-threatening sickness or cancer, and it might take them over a year maybe to recover, to be able to put things in place. So I do not know if a year is going to be sufficient, but that is something that can be looked into as well, Madam President. Madam President, also in the legislation, on page 47 of the legislation, where you have the various thresholds, it is not very clear on insolvent person, where it says that insolvent person means a person who resides, carries on business, or has property in St. Lucia, whose liabilities to creditors provable as claims under this act amount.
What page? Sorry, what page?
Page 47, Madam President. Insolvent person. A. Yeah. Amount to not less than the threshold specified under section 42A, 43, 8A, 62, 3C, 82C. The threshold is not clearly defined and stated, Madam President, so I do not know if Leader of Government Business can shed some light on that, on the threshold you're talking about, or if it is going to be in the regulations. I'm not sure, so if you can just shed some light on that, Madam President. There is one on the, I think, prior claim for of farmer of fisher folk. I wanted some clarification, Madam President. Let me just get the page. It's 189, section 189, sorry, Madam President. 189 and also 188. Prior claim of farmer or fisher folk. One, where a farmer has sold and delivered products of agriculture, or a fisher folk has sold and delivered products of the sea to a purchaser for use in relation to the business of the purchaser. B, the products were delivered to the purchaser within the 15-day period preceding the day on which the purchaser became bankrupt, or the first day on which there was a receiver in relation to the purchaser. That's C, as of the day under paragraph B1 or 2, the farmer or fisher folk has not been fully paid for the products. And C, the farmer or fisher folk files a period of claim in the prescribed form in respect of the unpaid amount with the trustee or receiver within 30 days after the day under paragraph B1 or B2. And then it says that at the end, Madam President, it says that in 4, this section, the same 189.4, does not preclude a farmer or fisher folk from exercising the right that the farmer or fisher folk may have under section 188 to repossess a product of agriculture or a product of the sea. And I think that a little more coverage should be given to fishermen, to fisher folk and farmers, because say, for example, a farmer, Madam President, is selling to a restaurant, one of the high-end restaurants. He's a consistent supplier to that restaurant, and that restaurant, today he comes to deliver, and that restaurant goes into receivership, into bankruptcy. it means that the farmer have to wait for the 15 or 30 days for the outcome of the proceedings. And if he doesn't want to file on that prescribed form to recover his monies from the receiver, he can go back and repossess the items which he sold to that restaurant. And you know, there is a shelf life for fish, there's a shelf life for produce. For him, I mean, how does he go into the refrigerator and say that this is my product I sold to you and so on and take it back? So I think there should be something where fisher folk farmers, whatever monies, whatever that is there to be distributed, they should be given priority in getting compensated before anything or anyone else, before the lenders themselves get their share from the assets, Madam President. Another question I had for the leader of government business, Madam President, was whether there was any consideration, because I know that this is going to, it says that Section 425, Title 9 of the Commercial Code, Cap 244 of the Revised Edition of Laws, 1957, is going to be repealed, and that is going to be taken over. But was there any consideration for like a godfather clause in the legislation, Madam President, before it is enacted? And also, is there going to be more public education, public sensitization regarding this legislation? Because this is very, very big, it is very consequential, and I think the public needs to understand and know all about this legislation, the pros and the cons in this legislation, Madam President. All in all, Madam President, this is what I have to say on the legislation, and let us see how it unfolds. Thank you, Madam President.
Senator Fede.
Thank you. Thank you, Madam President. Madam President, based on everything I've heard so far, the government would like to leave with the people of St. Lucia the impression that this bill is somehow going to make their lives better. But Madam President, I'm here to disagree vehemently with that position. That position, Madam President, is wishful thinking. That position, Madam President, is far removed from the provisions that are enshrined in this legislation which this government is about to pass here today. Madam President, a mortgage is a very sentimental thing for a lot of families. A lot of families see owning a piece of St. Lucia or owning a home as the ultimate dream. They see it, Madam President, as arriving into the middle class of St. Lucia. Madam President, property has an emotional connection to it, to many families. Madam President, many families today still cannot afford the down payment to go to banks. In fact, Madam President, a lot of people start with land packages only. And what they do is that in those packages, they would save up and they would juggle bills. And the first payment that would come out from the bills and the monthly expenses would be that of what has to go to the bank to acquire the piece of land and to give the family some level of ownership of immovable property. I have a friend of mine, Madam President, who some 30 years ago would have bought his land from the then HUDC. And I think he paid $45,000 then for that piece of land. And it required him 15 years, Madam President, to pay off that land before he could actually approach a lending institution to go and build a home. He will finish paying for this mortgage, Madam President, long after his retirement age. Madam President, many families in a lot of the outer districts, because of the trepidation and the fear of losing their property, of dealing with banks, and the draconian policies that sometimes can be applied to people who borrow monies to build homes. Many families choose the Kudme method instead. They build out of pocket. They go block by block. They go steel by steel. They go, boss man, help me with a bag of cement. You know, there's a fire victim recently that I know very well who lost his property to fire. And there was no insurance. There was no bank loan because the banks haven't shown that sensitivity, Madam President, to someone's own financial capacity or the personal situation of someone. And what he has had to do, Madam President, he's now building his home from scratch. And I'm inspired by people like that. Even though there's no bank involved, there's a lot of resolve, there's a lot of passion, there's a lot of hope, and there's a lot of faith that he can build and complete his home that he has lost due to the fire. So, Madam President, it is with a lot of emotion that I researched and reviewed this legislation. And I was taken aback looking at the debate in the lower house and watching how we had a propaganda piece by the government that failed, Madam President, to give a very balanced account of what is taking place here in the Honorable House, of how people are far more exposed. And my colleague was absolutely right. And when he was asked whether people who made the determination that he was giving an opinion, I don't think that if I go to a legal mind for legal advice, that it wouldn't be within the context of the law. I'm not talking to an economist, I'm talking to a legal mind. And of course, lawyers go to legislation to give legal advice. And so when a legal professional would opine on something, it is within their interpretation of what the laws relating to that matter says. And so we can try our best here to undermine the arguments that are being made, but the points still remain the same. Madam President, the insolvency bill, this is what it does. So the bill, as far as I see it, when you go through the sections that deal with the functions and the powers of the supervisor, and you look at all those provisions, Madam President, you will see that the powers of the supervisor and her roles and responsibilities, all of those are skewed biasly towards the lending institution. Very seldom in the provisions for the powers and responsibilities of the supervisor do you find that there are enough safeguards for the people of St. Lucia. Madam President, whilst there is some effort made in this bill to offer some level of protection to people and their primary dwelling home, that those safeguards don't go enough to protect people who would have inherited property from their parents if they're not living in that property. There's no protection for your home in your childhood that you would have had all your memories that you now own with your brothers and your sisters together. There's no safeguard for commercial property, that if you invest in an Airbnb and you're encouraged by the government to get into tourism and the home sharing business, there's no safeguards here for that. The bank can come, unlike the previous act, where they needed a court hearing or they needed a court procedure. They don't need that anymore for commercial property. They don't need that anymore for Airbnb property. They can come and they can seize your property without a court hearing.
Senator Ferdinand.
Madam President, I rise on a point of order.
What is your point of order?
The opposition Leader of Opposition Business is grossly misleading with his last statement to suggest that with this piece of legislation, the bank does not need a lawyer. In fact, this piece, a court procedure, when this piece of legislation, all it does is it extends the period within which there can be a negotiation between the client and the lender. He's actually misrepresenting, grossly misrepresenting what the legislation says. And we cannot allow, and he actually is moving away from the dwelling house and is going into the commercial sector to cover the argument. But it remains correct from this legislation that the bank procedure has not changed. It only calls for more time to be given for the process to begin. So I believe that statement is deliberate and should not be allowed to get away.
In any case, senators, I think it would be prudent for referring to the document, to the act when we are making the points, both sides. Okay, so if you are making that point, Senator Fede, you need to show us where exactly it is stated. Likewise, to rebut and say that it's misleading, to give us the corrected version.
Fair enough, Madam President, but you know, I have a number of sections that I'm about to show the member, and I know they'll walk into the trap. Because you see what's happening here, Madam President, is that they have drank the Kool-Aid of the propaganda they have heard in the lower house. And so they come here not having read the bill properly and to understand what's going on, that they are now coming to give this propaganda. We see this all the time, right? Now, if I may, let's go to, I mean, and the member has really interrupted the flow of my debate because that section comes really down. And he has come with no provision. But I will show you, Madam President, because I'm going through this in chronological order, and I have my pages marked out. I will show you before I sit down where that point comes in. Okay? Don't worry, that was just the intro. So, Madam President, I will not be disrupted by people who unfactually try to challenge the veracity of what I'm saying. No, he cannot quote the legislation because he didn't read it. Now, Madam President, when someone becomes a bankrupt, we are perpetuating a great disservice to that person. And I want to say again, okay, that person cannot incorporate a business in St. Lucia under the Companies Act of St. Lucia. Cannot. When someone takes the advice from a lawyer, and this talks about voluntary bankruptcy that someone can file for, the person cannot be an MP. They cannot be the president of the Senate. Madam President, if you, God forbid, becomes bankrupt, you have to vacate the Senate within 31 days because you have now become a bankrupt person. Those are the laws in St. Lucia. And so I'm speaking to the president. Allow us to converse. Why y'all getting involved with me and the president? Relax. I'm getting to y'all, don't worry. So Madam President, you see, jealousy is something, we have a great relationship today and everybody is jealous. But Madam President, look, I want to go to the Companies Act, okay? And Section 34 of the Companies Act. And I knew what happened to Herod would happen, and that's why I print everything.
What happened to who?
Senator Herod Stanislaus. We are brothers, and whether I'm in the Senate or I'm on the streets of St. Lucia, he has allowed me to call him Herod because we're good friends.
In this space,
so, no problem, Madam President, Senator Herod, no problem. But I don't think he's offended. And I know that what has happened to my colleague senator, you see, when people cannot challenge you on the fundamentals, they split hairs. Why are you calling your friend by his name that he is affectionately known? That's okay. Now, the tenure of, before I get to the the Senate. Let's go to the Companies Act as promised, Madam President. Companies Act, Part 1, Section 4, Incorporation. Incorporation. Under the incorporation section of the Companies Act.
Madam.
Yes, Senator Ferdinand.
Thank you, Madam President. I'm standing on a point of order.
Yes.
And I note the previous statement that I made. And before Senator Fede can escape and try to move to another section, I want to draw the attention of the Senate to page 201, section 296.
Page 201.
The document that he's...
Page 201.
The Insolvency Act that is before us, section 296. The senator made the assertion that under this new legislation that the court is not needed. And I am drawing his attention to what the legislation says under section 296 on the power of the court in relation to application for discharge. And Madam President, if we go to 2,
What
page?
Madam President, I've repeated that about 6 times. He
Page
probably is not
2.
following.
Senators, let us all listen to one voice because this has to be recorded and, of course, transcribed. When we all speak together, it brings the parliament into dispute. As well, the staff will have a difficult time deciphering who said what. So let's have some order. The only senator who's on his feet now is Senator Ferdinand. Please proceed, Senator.
Thank you, Madam
Leader
President.
of Government Business.
Madam President, I am simply making reference to the section that denounces and says the contrary to what Senator Fede tried to assert.
And for the purpose of recording, you said it's page 201.
Under section 296.
Section 296.
Number 2.
Number 2. Okay.
Notwithstanding, and I quote, notwithstanding subsection 1, at the hearing of an application for discharge, the court shall, on proof of any of the facts under subsection 3, A, require the bankrupt as a condition of his or her discharge to perform certain acts, pay monies, consent to judgments, or comply with other terms as the court directs. B, suspend the discharge of the period the court thinks proper. So, Madam President, and I can read the rest, because under 3A, it makes reference to the court again. And Senator Fede attempted to stand up here and say to us, based on, I don't know what he was reading, that the court is not required for these things to happen. And so, Madam President, I really wish that, having substantiated my point, that Senator Fede can use the legislation to tell us that what he asserted is the case. And if he cannot, Madam President, he should withdraw the statement that he made. Thank you.
Senator Fede.
Well, first of all, Madam President, what the member read in section 295, it begins from section 296. So that has to do with the discharge of the bankrupt person. And I want him to read that properly. Now, I will go to my section because that is absolutely incorrect.
Your section?
I will go to the section that I am referring to, since he wants it now. Madam President, if we go to page 76, it starts from page 76, section 47. I will actually go to, so it starts from section 47, and it goes, subject to subsections 2 and 3, and section 390 and the bankruptcy of a debtor, until the trustee is discharged, a creditor shall not do the following. And it goes on to state what those are. Notwithstanding this act, unless the court otherwise orders, the bankruptcy of a debtor does not prevent a secured creditor from realizing or dealing with the secured creditor security. Number 3, where the court makes an order under subsection 2 the court shall not postpone the right, okay, of the secured creditor, the bank.
That's right.
The bank is the secured creditor. The court cannot postpone the right of the bank, okay, to realize or deal with his or her security. And there are a few exceptions here. Yeah? So the court cannot, the court shall not, it did not even say may, the court shall not postpone. The bank, notwithstanding any procedure, can move in on the person's property, which is what is called security. Let's not complicate this. Right? So what you're saying,
Senator Ferdinand.
what you're saying is not true.
Senator Ferdinand.
An absolute untrue.
Senator
In
Ferdinand,
fact,
I have called Senator Ferdinand.
Thank you, Madam President. I know my name is Senator Ferdinand, and I heard you call me 3 times, and a different person was still talking. Madam President, I rise on a point of order. Senator Fede has tried to use the legislation to discount the exact point that I have made. And I'm happy that in every case, he started each statement with the court. His assertion a while ago was that these actions could have been taken without the court. But now he's telling us that under Section 3, where the court makes an order, and everything he said after that was dependent on the order that the court made. But he's, again, and I will not go into a drag on technical, I'm not a lawyer, and neither is he, and I'm not going to go into a drag on back and forth after I sit, Madam President, under this, but except to say that while neither of us in this chamber are lawyers, the substantive point that he has made that people's property could be seized under this legislation without the court is basically being discounted every time he reads. And so, Madam President, for the benefit of us lay persons in this chamber, I would wish that we are not here to interpret legislation. I would wish that Senator Fede not use the legislation to try to mislead everyone listening with arguments that he takes in pieces and ignores some of the other exceptions that are made in this piece of legislation. I thank you, Madam President.
Senator Fede and Leader of Government Business has indicated there will not be a back and forth. As indicated, we are not lawyers. However, the point has been made on both sides. I ask you to move on.
Madam President, I hope you'll be as generous as you were with him. In my point of orders, he actually had a whole new debate in my time, allocated
your
to
time
me by
is
the
going
Constitution.
as you speak to me about process. Your time is going.
So I do note the generosity with which you have instituted there. But, Madam President, the point is clear that the people of St. Lucia are far more exposed, that not even the court in some instances can spare them. But anyways, you're messing up the flow of my presentation. So, Madam President, someone who is a bankrupt cannot start their life over by incorporating a business in St. Lucia. And so when we pass laws and we make provisions that ask people to volunteer for bankruptcy, we must be careful what we're asking them to do. We must be careful of the ramifications of the bills that we pass in the House. We must be truth to the people. We can't be reading the parts that suit our objectives and our narratives, but we must read the bill in its entirety and say to the people of St. Lucia, there are pros and there are cons. And nobody expects any legislation to be perfect. But this government is trying to suggest that what they are offering the people of St. Lucia here is honey, right? Is the land of milk and honey. Madam President, you cannot become a member of the lower house or the upper house if you are bankrupt. The Constitution is clear about that. That this is how this affects the people of St. Lucia. This is how it affects them in enormous ways. But yet this government would like us to think that this is in favor of them. Madam President, the departure of Scotia Bank, Bank of Nova Scotia, has a very interesting story and context. And the departure of many of the Canadian banks that once existed in St. Lucia, or many of the banks, is that one of the motivating factors is how difficult it has been in St. Lucia under the previous regime for them to foreclose on property in St. Lucia because of the Napoleonic Code. That's a fact. And this is where this legislation is coming from, piloted by the ECCB. The ECCB is driving this because the ECCB wants to stabilize the credit system of St. Lucia and stabilize the credit system of the region. This is the genesis of this legislation. They want to make sure that the credit situation, that the banks are happy and that they have a set of rules by which will encourage them to lend more loans. That's a fact. Check the Economic and Social Review. Liquidity in the banks are up. Lending is down. Fact. Nobody can argue that. And you know why lending is down and liquidity is up? Because of risk. Because of the difficulty that exists in the previous regime that Senator Stanislaus spoke about, that in comparison to other jurisdictions in the Eastern Caribbean and CARICOM, that it is difficult in those jurisdictions in the Caribbean with the Napoleonic Code to foreclose on people's property. So how is it that you are bringing a legislation here to make it easier, basically, to please the banks, and you are saying at the same time that St. Lucians are better off with this? No, they're not. They're absolutely not. So you can twist the propaganda, and I know what the message has to be, but that's not what it is. Anyway, section 65. Sorry, page 65. Page 65. Section 19.4. Page 65, section 19.4. Section 19.4. Subsection 19, subsection 4. So it says here that a valid insurance policy or bond under subsection 3B, Roman numerals 2D, must be of an amount specified by the supervisor against a number of these prescribed risks that are listed here from A to D. Now, I have no problems with the insurance, and I have no problems with the bond to make sure that someone who is a trustee or someone who's a liquidator or a receiver manager would have the coverage. What I do have a problem with is the amount of discretion given to the supervisor alone to make that decision. I think that that has to be more widely consulted on, where the level of coverage that these individuals are going to have must be agreed upon by the industry and by a wider group of stakeholders. By the way, Madam President, I don't believe, listening to the Attorney General who presented the bill, I don't get the impression that this was widely consulted on for the ordinary people of St. Lucia. So I listened and I took notes. The AG says the following. He said that he consulted with the Consumer Association, the Chamber of Commerce, the Bar Association, and the Bankers Association. I didn't hear wide public town hall meetings so that the regular property owners themselves understand what's happening here in the Parliament of St. Lucia. And so for me, speaking on consultation, speaking on in the same theme, I believe that the level of bond to cover the risk of people's property should be widely consulted on and should not be left to one person to decide what that level of coverage is going to be. On page 76, section 46(1), page 76, sorry, it should be 47, 3A. Page 77, rather. Yeah. And so, Madam President, no, 46(1) is correct. 46(1) on page 76. So, what we see here, Madam President, is that where the court grants a bankruptcy order, the legal costs of the applicant are taxed and payable out of the estate unless the court otherwise orders. Now, Madam President, if you are acquiring an estate via credit from a lending institution, part of that lending institution's corporate tax is passed down to you. And that's built into the cost of their interest. So here you are now, falling on hard times, in some financial difficulty. You're going through the period of bankruptcy. And not just financially are you put out, but emotionally as well. You are distressed. You are at the risk of losing your home. And then the government then contemplates that there could be an option where they're going to be for the taxes. Really? So I know the government side will want to say that they're taxing the bank. But it is payable out of the estate of the bankrupt person. What's the law that you brought here to Parliament says? Very clearly. And I see the leader of government business looks very perplexed and confused. Because, again, unless you go through the detail, Madam President, you wouldn't see the devil. The devil is in the details. And it's here. So when I say that this is draconian, this is what I mean by draconian. That someone would have had to go through these circumstances and yet be taxed. But you are already taxed. You are already paying, the bank is already passing on their high interest rates to you. And it is from their profits, which they gain from you, the consumer, that they are paying the government corporate tax and all the other license fees that you are contributing to. All of the costs associated with the bank's own expenses. So, Madam President, this is draconian. This is inhumane, and this is uncaring. Madam President, getting to page 77 now, and on page 77, section 47(2), and I'm going to go all the way down to subsection 4. Notwithstanding this act, unless the court otherwise orders, the bankruptcy of a debtor does not prevent a secured creditor from realizing or dealing with the secured creditor's security. So, section 3, where the court makes an order under subsection 2, the court shall not postpone, the right of the secured creditor to realize or deal with his or her security. Madam President, the court shall not postpone. The bank can move in when they see fit. Punto final. I'm getting to the exceptions, Madam President. Don't worry, Madam President. I know you like the debate. Don't worry. I'm getting there, right? But I have to exhort on every verse of Scripture. I know you're a woman of the word, yeah? On every verse of Scripture, I must give an exhortation. So on this particular verse, Madam President, it is said here that the court shall not, this law prevents the court from postponing the bank from moving in on the person. So there's no protection. Where is the phrase that you protect someone, right, in this clause? It doesn't exist. It doesn't exist. Goes on to say, except, there are a few exceptions here. In the case of a security for debt that is due at the date of the bankruptcy, or a security for debt that becomes due no later than 6 months after the date of the bankruptcy. So you have a little 6 months. But when that expires, crapo smoke your pipe. And that doesn't mean that a person would be financially rehabilitated in 6 months to get back on track to try to stave off the mercenary move that a bank can make on them. That is the reality of the law that we have brought here
Senator Fede,
to the House.
you have 10 minutes to complete.
Yeah, thank you, Madam President. You mean all that time that the leader of government business took from my time, I don't get it back? So now I will have to skip some of these and go on to more pertinent. And then 4, subsection 4. An order shall not be made under this section if the order prevents a secured creditor from realizing or dealing with a financial collateral. Yeah? Madam President, we move on. We move on. Page 80. Page 80, section 51. Is it? Yeah. Section 51, subsection 1. An assignment or a bankruptcy order made under this act takes precedence over a judicial process, including attachment, garnishment, judgment, execution, or other processes against the property of a bankrupt. So you see here, the supervisor who is empowered to give that assignment doesn't necessarily need a court process to go through it. In fact, it says the assignment takes precedence over the judicial process. And I want the members to read that carefully. That's what it says. That's what the law says that you're bringing to this House. And so when I say to you that the court can be circumvented, believe me when I'm telling you it's the truth. This is the gospel that you've brought to the Senate. It says very clearly, and I'm reading for an assignment which is given by the supervisor, or a bankruptcy order made under this act takes precedence over judicial process. How you mean it can't be done without the court? That's what it says. You have to read the thing carefully and slowly and go to the different parts and relate it to all the subsections. It is said so clearly in the law that the government side has brought to Parliament. You've exposed the people of St. Lucia. But again, you have a narrative to put out. Go ahead and put out your narrative. Our job is to be more balanced than that. Our job is to make sure that the people of St. Lucia know what is in here, because the consequences are dire for the ownership and the sustainability of the ownership of their respective properties. Their hard-earned monies that they have worked so hard to get. Yeah? This is how egregious this is. Page 82. page 82, and it talks about lease. This is how draconian this has become. Surrender of lease dealing with leasehold, interest by trustee. Section 54. And if time permits, Madam President, I'm going to go all the way down to subsection 6. Where a certificate of assignment is issued by the supervisor or a bankruptcy order is made by the court, and a bankrupt is a leasee of premises, meaning that you're renting the property, the trustee, notwithstanding a condition, covenant, or agreement in the lease, has the right to hold or retain the lease premises. This is the law that the Labour Party has brought to the House. That's the law, right? The trustee has the right to hold and retain the lease premises until the expiration of the tenancy on the same terms and conditions as the leasee might have held the premises had no bankruptcy occurred. That's how draconian it is. That someone can come, a trustee, who becomes a trustee in the process under this act, can come and take control of a lease, even your rent. Even your rental contract is under the gun, is exposed. That's the law. That's the draconian nature of this, which is why we did not.
You have 5 minutes to complete.
Thank you. Which is why the opposition, when we were in government, the United Workers' Party administration, we had great pains and we thought about this because this is serious business and the implications that this have on the people of St. Lucia are enormous. They are inhumane. The tenancy of the lease premises under subsection 1 terminates on the trustee disclaiming the lease, but notwithstanding prevents the trustee from transferring or disposing of the lease, leasehold property, or any interest of the leasee for the expired term as could have been done by the leasee. It does this. It protects a landlord, but it exposes the leasee. And this is what the other section says, is that they can actually take monies from your estate to pay outstanding commitments to the landlord. These are all facts in the law that you have brought here to the Parliament. So the opposition has a lot of reservations about this bill. And time doesn't permit me to go into a lot more that exists within this draconian piece of legislation, which has untold effects on the people of St. Lucia. This doesn't make it any safer. I want and I challenge the government side to show me where it protects commercial property and where it protects people that have invested in Airbnbs. Outside of your primary home, I want you to show me where your inherited home from your father and your mother is protected if you're not living in that home. That's a fact. They are wide exposed, and those foreclosures can be done without the court procedure because the banks don't want to face the long drawn-out procedure where your rights can be heard, where your opinions can be heard, where your case can be heard properly. And that's a fact in this legislation. That's right. But they don't want us to say that because it doesn't suit the narrative. It doesn't suit the propaganda. It doesn't suit the Kool-Aid that we're all supposed to drink. We don't drink Kool-Aid. We're a people of facts because we recognize that when you pass a law, it's not a joke. You're having tremendous impact on the life of the people of St. Lucia. And so we must take time to make sure, Madam President, that we pass a law that is fair and that is just, and that's in the best interest of the people of St. Lucia. This one is not. I thank you.
Senator Antoine Prosper.
Madam President, I rise to support the enactment of the Insolvency Bill, a bill which is of profound significance to our economic landscape. Madam President, I will not claim to have read this immense document from cover to cover, but sound and look obviously confused and extract parts out of context. Madam President, my training has allowed me to succinctly extract the most salient parts. I would not behave like some who signed a voluminous document and admitted that he did not read it. Madam President, in our part of the world, most of us come from humble beginnings, and therefore, any large investment, such as building a home or starting a business, has put us at the mercy of the commercial banks or other lending institutions. Madam President, this legislation is not merely another procedural formality, but the cornerstone to financial stability and fairness in our economy. Some say that it was forced upon us, but I wonder whether they can say that it is not timely and necessary. I heard of high liquidity and low lending, but we are aware of the impact of loss of jobs, loss of income post-COVID, and its impact on lending in our society. Madam President, this process has taken 10 years to reach this House, as we have heard before, and is long overdue, as too many families and entrepreneurs facing financial distress have suffered loss of their property and businesses in the absence of a structured framework for orderly resolution of debts. Madam President, jodi a nou vini si a avec nou vle passer en loi parce que nou jawe trop famille qui ja touime wed pour faire un petit caille et bien pour commencer un petit business. Peut-être yo te malade. Et bien yo perd travail yo. Avec banque lan ja saisi caille la yo pa ni côté pour mettre famille yo. Et bien petit business là qui te ka aider yo pour voir riche yo l'école et bagay comme ça. Petit business là descend en bas parce que banque lan saisi ça yo teni. Nous savons dans ti commune côté moun toujours ka vinn demander crédit. On chay business, on chay moun za pet business yo pour la petit ça. Avec jodi à nous ici parce que nous voulons faire une loi, ranger loi pour faire plus difficile pour banque et l'autre institution pour saisir property, pour saisir caille Jean Saint-Lucie. Nous venons ici parce que nous voulons mettre une législation en place pour ni ces mouna ni banque là, ça résolve les affaires primaires pour yon side pas ni trop pédant passer l'autre. Madam President, we have observed that financial institutions have been concerned about collecting their debt with little interest in the loss to the customer when they have defaulted on their obligations. Madam President, at the moment, the laws of St. Lucia offer no debtor protection. A debtor has no way to stop a creditor from collecting on his debts. Senator Stanislas said that this bill provides a longer period for the creditor to seize property. Madam President, I believe that this is a positive because it gives the debtor more time to resolve the issue and an opportunity to regain his or her property. Let me remind the Senator Fede speaks to the interpretation of this bill by legal minds. Let me remind the Senator that it is the legal experts who prepared this bill, and therefore there should be no issue with the legal interpretation of the bill. This bill provides a clear path for the reorganization or liquidation of debt and helps preserve the value of distressed assets and support the recovery process. Madam President, through the Office of the Supervisor of Insolvency, the defaulter will be able to file a proposal or notice of intention to file a proposal. The debtor can stop creditors from enforcing this right to collection. They will be able to renegotiate new terms of payment on their loan and have less stress from the creditors. Madam President, this bill fosters transparency and accountability. It sets our clear rules and procedures on how insolvency should be handled, thereby minimizing uncertainties and potential abuses. Madam President, it provides creditors, investors, and other stakeholders with the confidence that the interests are considered fairly. Madam President, with the enactment of this bill, there will be the regulatory process will balance the rights and the interests of both the lender and the borrower. There are guidelines for handling conflict between lenders and borrowers. Creditors will be more certain about recovering monies lent, and the number of non-performing loans will certainly be reduced. Madam President, this bill gives primary homeowners an opportunity for a fresh start rather than being forced out of their residence. A homeowner will have a certain amount of equity in their primary residence that is exempt from the creditors. It means that in the event that the property is sold, an amount is given to the homeowner to help him start over again. Nou ka di, Madam President, le bil sa la ka protekte moun ki ni kay yo paske la ni on katite l'argent ki met kay ni a sou kote. Pou si bank lan van property a, i pa kay ped tout bagay. I kay ni on amount l'argent ki kay a sou kote sa jwen pou aider y commencer encore. Mania situation y actuellement, ça c'est bank la ka fait. Ça ou doit ya depuis yo sa vend property a pour yo faire l'argent yo pa mêler avec ou encore. Bill ça là ka dou bout sa pour ou sa joindre en bagay parce que si on monde kon sénateur Gibeon Tekadi si ou ja payé en loan pour quantité l'année il pas bon pour perdre tout bagay avec c'est ça bil ça kan péché pour perdre tout bagay at least ou sa joindre on l'argent pour commencer encore. Madam President, many small businesses and entrepreneurs are particularly vulnerable to financial setbacks. This bill will provide these businesses with a chance to reorganize and continue operating rather than being forced into premature liquidation. Madam President, this does not only help preserve jobs and contribute to the overall health of the economy.
Madam
by
President,
maintaining a diverse...
I stand in the point of order.
Senator Fede, we are going through this again. You put on your mic. I call you, you stand. You are actually on your feet.
My apologies.
You put on your mic. Senator Fede.
Yeah. So, Madam President, I stand in the point of order.
And what is your point of order, Senator Fede?
Yeah. I find it very hard
Senator
to...
Prosper. He's standing on the point of order.
Yeah, I find it very hard to follow the member with the legislation because she's not quoting the section, so I don't know whether this is taken from another bill or this legislation, or her opinions are from somewhere else.
Please proceed.
Thank you, Madam President. Madam President, this not only helps preserve jobs and contribute to the overall health of the economy by maintaining a diverse and dynamic business environment. Madam President, there is no doubt that this bill plays a vital role in encouraging more prudent financial practices and responsible lending and borrowing and reduces the likelihood of reckless and risky financial behavior. Madam President, I am aware that a public awareness campaign has started. It is my hope that the public will be adequately sensitized and they will be well informed of the provisions of this bill. Madam President, I am convinced that enacting this insolvency bill is not merely a matter of regulation compliance, as some have indicated. It is an investment in our economic stability and our economic growth. It ensures that financial difficulties are addressed in a fair, transparent, and effective manner, protecting businesses, creditors, and the economy at large. Madam President, by passing this legislation, we are laying a foundation for a more resilient and equitable economic system capable of weathering financial challenges and supporting the long-term prosperity of our people, our businesses, and our nation. So I have no doubt that this piece of legislation is timely and it will be effective in assisting St. Lucians in dealing with issues of liquidation, in dealing with issues of defaulting on the payment to financial institutions, in giving St. Lucians a peace of mind that when they invest, there will be hope that if there are issues, if they have difficulties, there will be a process that will enable them to recover. And this is why we are here. So I do not know where the naysayers have read what they have read to come to this house and say that they do not see. I suspect, Madam President, some people probably need a new pair of glasses. So when they read, whatever they are reading is what is on the paper. But Madam President, I have no reservation in supporting the enactment of this bill. I thank you.
Senator Jean.
Thank you very much, Madam President. Madam President, I rise in support of this insolvency bill. Though I have sat here this morning and had to endure presentations from a perspective of gloom and doom, I just want to, Madam President, highlight what I see as the uniqueness of this bill. In fact, Madam President, as I sat here this morning, I really got a better understanding of the maxim that the truth is what you believe the truth to be. Because I cannot understand how we could take a piece of legislation that has the interest of both the creditor and the debtor and just paint it as if it is all skewed to one party. Madam President, what I find in the bill is that it provides clear guidelines on resolving conflict between a creditor and a debtor. That's what I find out of the bill. And in comparing what obtains today, what I find also unique is that there are intermediaries who would be assisting the parties in coming to a resolution of that conflict. So, Madam President, as the leader of government business in his presentation indicated, there are, when one is pursuing a debt, there is a responsibility that comes with that debt. If you have to go to a creditor, be it a financial institution, be it a hire purchase company, be it a shop, be it a farmer, wherever you go, as long as you are going to be incurring a debt, there is a responsibility that is assigned to you because you are expected to repay that debt. So whether it's Airbnb, whether it's whatever it is, you must be responsible for it. This bill is not for Jackie Mauvais Pay, because there are people who just have a habit of incurring debt and not paying it. You know, there are some people, when they get paid, before they can go and pay their debts, they go and stand up by the rum shop, they drink a little shot, or they pay for their fetes, their parties, and so on, and then leave the debts unpaid. Financial institutions and creditors are in business, and they are looking forward to having their business secured. And so it is important for both the creditor and the debtor to be secured. So we cannot be just talking about, oh, the debtor, the debtor, the debtor, the debtor, the debtor, and then the creditor goes away. Because what is going to happen is that you're going to get the creditor to be a debtor himself, him or herself. And so what I'm seeing out of this piece of legislation, Madam President, is that it allows for there to be a process for both the debtor and the creditor to come together to resolve the conflict that would have occurred because the debtor would not have paid his obligation, his or her obligation. Another unique aspect of this bill, Madam President, is now the inclusion of the supervisor of bankruptcy and insolvency as recorded in sections 6 and 7, where it outlines the powers, the functions of that supervisor of bankruptcy and insolvency. Because currently, as it exists, the debtor would have to interface directly with the creditor, with no one to assist in that process. And so most times the debtor would have to get an attorney, a lawyer, to intervene on their behalf. In this case, the supervisor of bankruptcy and insolvency serves as a kind of a mediator overseeing the administration of that estate, and that is recorded in sections 6 and 7, and it includes that estate, including one which is administered by a government trustee. So the government is now putting in an administrator of that process. That is the uniqueness of that bill, of this new legislation, and serves as a safeguard for both the debtor and the creditor. In addition to that, we're seeing now where the debtor can present a proposal. And in this case, the law prescribes two types of proposals: a general proposal and a consumer proposal. The consumer proposal, as outlined in the interpretation, section 2, actually states, and I quote, Madam President, if you would allow me to get the consumer proposal.
For the record, you want to state what page you are?
Page 42 is in the interpretation, but it takes me to Division 6 of Part 4. So let me just go to Division 6. Somebody gets it before me. So it's on page 113, Madam President. It states, it outlines the whole manner in which the consumer proposal is to be presented to the supervisor of insolvency and bankruptcy. That consumer proposal will include the factors that are lending to the debtor's inability to repay at that time. So, Madam President, in this case, you are caught with a terminal illness. And Madam President, we're seeing it so prevalent nowadays. So many people are being diagnosed with the dreaded big C, cancer, for example, and may have to take a break to undergo treatment for a period of time. Some of these treatments go beyond 6 months to a year. Or that proposal can include a layoff by an employee, to the hotel workers who are being placed on rotation. At the time when they took the debt, their salary was at a particular level, but now that they're on rotation, their salary is reduced and they're unable to meet the full obligation. That is the provision in the law that is made for them. Madam President, I see this as unique because currently as it exists, if your obligation to an institution or to a creditor is a particular amount, say $1,000 a month, regardless of your circumstances at the time, you have to pay the $1,000 a month. And if you pay less than the $1,000 a month, interest accrues on the arrears. By the time you check yourself, your principal plus interest is double or triple, or like someone said before, double the amount. So, Madam President, this process allows a debtor to have somebody go through the process, mediate with the creditor to seek to have a reduction in what it is. But Madam President, for me, the greatest uniqueness of this piece of legislation is the fact that your principal residence, and that is highlighted in section let's go back to the interpretation section. Principal residence. Let me get the page. Page 49, Madam President. There is particular care taken to protect the principal residence of that debtor if that residence was what was used as security for the debt. So in this case, it says principal residence means property for the year prior that is used as the principal residence of and is occupied by the owner, a housing unit, a leasehold, and so on. And Madam President, if we go to section 173, let me get the page for you. Page 132, where it outlines the property of the bankrupt, and it says the property of a bankrupt divisible among his or her creditors. In there, Madam President, provision is made for when the property is sold, that proceeds of that property would go to the debtor. As it pertains now, and I think my fellow senators on this side correctly indicated that right now, all the bank wants is what you owe them. Your property can cost $100,000. If you owe them $20,000, they will sell your property for the $20,000 that you owe them, and that's it. So notwithstanding the equity on your property, the bank looks after its own interest and nothing else. This new piece of legislation is saying no. We have to look at the uniqueness of this legislation and let the people of St. Lucia know, the bright people of St. Lucia, not the 43%ers, but those who know better, that this piece of legislation would allow them to get some proceeds of the sale. So the bank does not determine how much they sell the property, only to safeguard their interest and not the debtor's interest. So that is the uniqueness of it. And more so, in section 174, which is on page 134, it says, and I quote, "The minister may by order publish in the Gazette prescribe the standards for determining the portion of the total income of an individual bankrupt that exceeds that which is necessary to enable the individual bankrupt to maintain a reasonable standard of living." So, Madam President, là ou fini là ek bakla, ebe ou fini ek kots e kote ou pou kredi. Notwithstanding that your circumstances have changed, this legislation and the government of St. Lucia under the Labour Party administration wants you to still walk away with a reasonable standard of living. That means you will not be walking away as a pauper. For example, you know, sometimes in our youth, we get a little job, things nice. We go, we build a big 3-bedroom house. We fall on bad times, you know, you never know. Fall on bad times, you lost your job, you know, things bad. You lose the little 3-bedroom house you built. But out of the proceeds of that 3-bedroom house, you might be able to build a 1-bedroom. So, Madam President, you're not down and distressed as those on the other side would want you to believe. This piece of legislation is not one that will cause you to be on the street. It has created an administrative process to hold your hand during that time. And this thing about you don't have to go to court and you're not going to court, I don't understand where in this legislation that it says so. So, Madam President, I believe this legislation allows for the safeguard of the people of St. Lucia who are incurring debt, because it's inevitable we're going to incur debt. But what I want to advise, Madam President, is that people don't use this legislation and incur unnecessary debt or go into debt and disregard the debt. We need to be careful about the credit cards. The credit cards are sweet when we just get them. I remember being young, you know, first time you hear of credit card, you go and get credit card. And, you know, my first credit card, they gave me $2,000. And within maybe a month or so, I blow off the $2,000. And then, when I tried to repay Pli mwen paye credit card sa, c'est pli credit card la pa descend. Like you cannot breathe. You have to be able to manage these finances. You have to be disciplined when you're going into debt. So it's not to say the bank is a dragon, and banks, just banks taking your money, banks taking your money. It's not banks taking your money. You go and take your money. You go and take the bank's money. You have to pay back the bank's money. But you must be disciplined in the process. So the way I see this legislation, Madam President, is that it allows for ease of getting debt. It gives a responsibility for maintaining the debt. It also gives you an avenue if you are unable to pay that debt over time. And lastly, Madam President, if you're running a business, Madam President, and you want to put responsible people in your business, will you put in people who cannot manage their own business in your business? Isn't that the reason why they said bankrupts can be senators? How could we be coming here and trying to manage the business of the whole of St. Lucia and we cannot manage our own business? I believe, Madam President, we should pay more attention to that so that some people who are sitting as members of Parliament would not be in this august chamber. You cannot be going there, want to manage the business of the people of St. Lucia, want to go and represent St. Lucia all over the world, exafel panet. You cannot conduct your own business. It can't be so. So, Madam President, on these few words, I want to reiterate my support for the Insolvency Act. And I believe that it is a progressive and courageous piece of legislation for the people of St. Lucia at such a time as this. Thank you.
Honorable Leader of Government Business.
Thank you, Madam President. It is always something I look forward to when I have to rebut after the opposition especially has given me a lot to feed off. And sometimes I have to truncate it because of the interest of time, and sometimes I have to take my time to ensure that I do justice to the discussion. Madam President, we came here this morning to pass this insolvency bill, and in my introduction, when I presented the bill, I made sure that I provided a proper context. In fact, I did not spend as much time as I could have on all of the details, the intricate details of the 274-page document, but in the interest of all members and trying to ensure that it is clear what the context is, I instead spent more time trying to explain the reason or the intent of the bill. But, as always, the leader of opposition business was late, so did not have the benefit of my presentation for him to respond to. And instead of dealing with the substance of the bill and the context that was provided, came with his script. And of course, the script has to be read. But again, using or attempting to use the very document to give St. Lucians one impression. That was the only thing the opposition came to do today. They came to give St. Lucians one impression, that we are coming to the Parliament with a bill that does not favor their interest, but favors the interest of the banks. That's what they came to do. No matter what else they said, that was their intention. And so we heard them referring to the banks as sharks. Referring to the banks as sharks. That name-calling thing, Madam President, is popping up again. And if the banks are sharks, I want to know whether we had fishermen 5 years ago, because they paid a lot of visits to those sharks. That's where Madi Poitier came from. Every Tuesday they were going to the sharks to get money, not to pay for housing assistance, not to pay for health care, but all kinds of things. Vaccine monies we can't get. So today, the opposition comes to the Senate. Instead of focusing on the benefits of the bill to the people of this country, they go and call names. But I think the bankers are listening and they hear what this opposition thinks of them. So yoka kuye se bank la wechen. Opposition vini ici à Madame Président. Nous menons un morceau de législation pour faire loi, pour faire plus aisé pour les simplicien ni un petit problème pour payer dette li, pour faire banque là avec moun sa la venir ensemble, pour yo ça faire un arrangement, pour bailler moun la une chance, pour y pas aller, pour yo pas point kaili. Mais opposition a kay vini jodi a et puis ka kouye non, yo ka kouye ces banque là wetien. Madam President, that intention of the opposition clearly run into problems. Because when you want to make an argument, you have to be able to substantiate it with fact. And of course, no matter how much it was attempted, as you saw the way it played out, Madam President, the opposition was not successful in doing so. And I'm very grateful for what happens when you stand on the side of truth. So, Madam President, if I may just draw out a few examples. If we begin by looking at the point that was made by the leader of opposition business, saying that he was supporting his partners or his colleagues, pardon that language, that's not his colleagues' argument that the argument was based on advice and consultation with legal minds. Now, while I liked the approach that Senator Stanislas took, and it's unusual he's not in his chair, that usually is the other way around, but I believe he has genuine reason. But I wanted him to be there to respond. He's usually there when I respond. Madam President, Senator Stanislas raised the argument that he is going to present some findings from some research that he did. And I realize you gave him that latitude. And I also thought that it was a reasonable thing to say because he didn't come here stating that he had particular research and, and he clearly admitted that it was not based on any particular fact. So his argument was, here are some of the things that I have an issue with because I have done research and in the process I have consulted with legal minds. I would like to think that these included lawyers. And so the leader of opposition business decided that he agreed with his colleague because the arguments were substantiated through consultation or discussion with legal minds. But Madam President, who presented the bill on behalf of the government? Yesterday, only yesterday, this bill was presented for the very first time we saw in this chamber. The Attorney General of St. Lucia, of this government, presented that bill in the lower house. And who is the Attorney General? The Attorney General leads an entire legal team, not just one lawyer. There were people sitting in the gallery, Madam President, part of this, the Attorney General's chambers, legal drafters, who drafted legislation when this government was in office. You party avocat? Sayote. The very same people. I don't think the staff of the AG's chambers has changed much. So you had an entire legal team and a renowned attorney, Attorney General Lasipa Avocatipa PA, Madam President. He's a serious, reputable lawyer who, in the wisdom of this government, allowed for him to present the bill, to remove all of the politically perceived biases that may be there. And that today, the opposition is claiming that their argument is based on legal counsel. Nobody knows who Senator Sanister spoke to. I don't know which lawyers he spoke to. Massav si se avocat il parle by. Ebe sa papier, Massav. But if he says he consulted with legal minds, I'll take his word for it. But let us apply the same argument to what happened on this side. You saw the lawyer yourself, Madam President. We saw the legal team, and we know for sure that the arguments that were presented by this side were presented by people with legal minds who have an authority on interpretation of this kind of information. So you see, Madam President, the opposition comes, they make an argument, and then they disclaim it when it suits them. So, Madam President, let's move on. The leader of opposition business has a way of using what looks like a piece of document, whether it's the social and economic review. For some reason, he didn't use it today, but he mentioned it. He beat it up so much, as he said, that he didn't cite it, but he mentioned it. And he's holding in his hand a few times. I had to stand up, but I waited to rebut because I always have that opportunity. He held in his hand a few times this very document, and if you look at mine, Madam President, you can see that I have, used my old teaching methods and put in my little post to get to the various sections that I need to. Obviously, I read. But he's reading from this, a habit he has had, reading from the document to misrepresent the information in the document. That forced me to have to stand up on a point of order a few times.
Madam President, I stand on a point of order.
You sit.
Oh,
You
sorry.
turn on your mic. I acknowledge you. You stand. Senator Feedy.
Yeah. Madam President, I stand on a point of order. The member is grossly misleading the House when he suggests that I deliberately I would pick up the legislation and read it to mislead. If the member has a different interpretation of the various clauses of the legislation, then so be it. But to accuse me of having a habit of deliberately using documents placed in this honorable House to mislead deliberately is disingenuous and taking it too far.
Please proceed, Leader of Government Business.
Thank you, Madam President. I always wait for your instructions before I proceed. If I may use an example to substantiate the point I just made. I recall, and many of us here were in this chamber, perhaps except Senator Charles, when the leader of opposition business, and I made that point to tell you that there's a habit, asserted that he had evidence to make a point. And you, Madam President, challenged, gave him the opportunity. I think it was, either it was yourself or different, I think it was the previous president, the previous, person in charge of the chamber. He left the chamber. Said he was going to the library. Remember that? Went to the library, came back. Existe toujours pour qu'on s'ajoigne évidence à y chercher. Si on mentionne y chercher évidence que pas qu'à joindre ni.
But Madam President,
Senator Feedy.
Yeah. Again, I have to stand on a point of order.
What's your point of order?
The member again is imputing improper motive against my own character in suggesting what he said. That has never happened. I have never brought a false document. I've always presented the economic and social review.
He didn't
I've
say. Hold on.
Yeah.
Correction. He didn't say
He's
you
implying
provide.
strongly.
You don't speak while I'm speaking, Senator
Right.
Feedy. Leader of Government Business said that you went to the library to get some information, and up to a day like today, you are not presented That's what he
Madam
said.
President,
That's not what he said.
Madam
I think you
President,
misunderstood
that's
what he said.
unfactual because I did present it to you. And I recall that day that you said to me to withdraw the statement. I did not have the budget book, which is the estimates of revenues. And I made it a document of the House and I gave everyone a copy. And I remember specifically that I made the assertion that the government was planning to borrow $505 million. And in the financing deficit, or the financing gap,
thank you.
it was $505 million.
We remember. Please proceed. Leader of Government Business.
Thank you, Madam President. I will proceed because, you see, the more I dwell on these things, the more this debate gets dragged into something that is not very classy. It's not like me to engage too much in this. But the point is made, and I'm thankful that you ensured that I was not misquoted when I said that the member brings documents that are not factual. I didn't say that. So, Madam President, the attempt by the opposition to derail the argument we presented for the purpose of, or the intention of this bill, is what I speak to. So no matter how many times he stands on a point of order to interrupt me, and he must remember that the time issue is not as bad against me as it was against him. So that will not work. You may stand leader of opposition business, he can as often as he wants to. This is the spirit in which we debate. Madam President, the essential argument we came here to present to the people of this country and to you, Madam President, and the Senate, is that the insolvency bill that we provided, or we are coming here to pass, has a particular intention. Now, intention is important. What is it we want to do for the people of this country? Madam President, bon matin, et puis après-midi, mais là nous venons bon matin, nous venons ici pour faire un bagay. Nous venons et puis un morceau de législation pour faire loi, pour faire moins qui des bagay. Yon, si un monde, on cet lycéen, prend un loan, eh bien, il y a une dette. Et puis, il trouve quoi dans une situation, côté, il passe à payer dette là. Nous venons ici aujourd'hui pour protéger moun ça là. Pour pas faire possible pour banque là en saisi kay moun là et puis mettez dehors. Bon, Madame Présidente, dis-moi comment ça pas bon, ça pas en l'intérêt simplicien. Comment l'opposition ça dit simplicien. Si le gouvernement vient pour dire nous avons point démarche pour empêcher banque là en venir avec saisi kayou, nous avons une chance pour et puis banque là ça a fait un arrangement pour pas saisi kayou. Comment ça pas en l'intérêt simplicien. Madam President, the second point on that intention is that if for some reason the asset has to be liquidated, that instead of the bank selling that asset for the balance that is owed to it and keeping all of the monies, it is better if the bank can sell the asset and the lender, sorry, the borrower, the person who is owing, can get a benefit out of that. Madam President, dis-moi comment si le gouvernement nous vient ici pour empêcher moun joindre bénéfice, nous venons nous dit un morceau de législation ça là, 274 pages. Ça, 274. Ça nous a dit c'est si un moun passe à payer l'ONU et puis banque là tout ça yo a fait des marches, yo passe à payer et puis banque là décider OK, nous kay ni pour faire un gamek kay ça là. Plutôt banque là en saisi kayou et vendre ba l'autre monde pour rien et qu'on pas joindre rien pour ça. Nous ka dit banque là les vendre ça y vendre là propriétaire ou qui doit banque là ou kay trouver anti cacadan, ou kay trouver bagay pour ou même ça faire des marches pour quoi. Qui manière ça pas en l'intérêt simplicien. Madam President, this is essentially the argument here. The intent of this bill is not about commercial businesses and all of those corporate tax. I heard the leader of opposition business in the same breath that he's talking about, this is about the banks, talking about property tax and all of those commercial tax and all of those things. mixing the argument, trying to confuse people here. Madam President, this bill allows for persons
Senator
to
Fede.
mutually resolve.
Madam President, I again have to rise on a point of order. I'm sorry for
What is your
disrupting. He's misleading the House again and misquoting me and telling untruths. I did not say anything about property tax. I referenced corporate tax. In the phrase, in one of the clauses of the bill, it states.
Yes, acknowledge. Yes.
Yeah,
Yes, yeah.
but it is important because
No.
it says that the taxes, the legislation speaks to it. And I
Senator
referenced the...
Senator Fede,
Yes, ma'am.
the senator has acknowledged that what you said is what it is. So you're continuing, but he has acknowledged. So please take your seat and let him proceed.
But acknowledging is not enough because it's wrong.
That is enough for me. So you take your seat.
No problem.
Proceed.
Thank you, Madam President. I acknowledge that the term used was corporate tax. So I'm man enough to say, I misquoted you. I say that. I meant to have said corporate tax, I said property tax. The point is not erased, however, that in the conversation, to try to make it seem that this is does not benefit the borrower, who is the average St. Lucian. And as I did indicate in the context that the main amendments that we are making to this bill, there could have been a whole lot of amendments. Look at the size of this thing. The amendments that we are making are specifically targeted to benefit the average borrower and people whose homes, their dwelling houses, we want to protect them from losing that. But he was speaking about that particular issue. How is this thing going to benefit people with the average dwelling houses? And in that same discussion, corporate tax. So, Madam President, people who, and Airbnbs, you see, he's bringing these things into the discussion when the whole focus of this bill is about dwelling houses. And we know that. It's about that. But Ikai Pale about corporate tax.
Senator Fede.
Yeah, Madam President, the focus of the bill, and again, the leader of the opposition, government business, has expressed an untruth. The focus of the bill is not only on primary dwelling home of someone. All over, that's what you said.
Well, you did say the focus of the bill was on,
and that's not the focus of the bill.
Yes.
You said it's the focus
Right?
of the dwelling house.
So other properties owned by individuals, commercial property, your second home if you have an Airbnb, is relevant to the debate and relevant to the legislation, your land, anything that you own. So, I mean, we need to tell the truth.
Please proceed, Senator.
Thank you, Madam President.
And he did not say it was
It's okay, Madam President. I have no problems with him, If there is any issue where I would have said anything that was not precise, I'm prepared to correct it, I will repeat, however, while the bill takes care of a number of other types of properties, when I made my presentation this morning when he was absent and was late, I made it very clear within the context of my presentation the intention of these amendments and this bill. Of course, the bill deals with other things, but there is an intent, and the word intention is important. Who are we really looking to protect? But his assertion was that the government is not protecting the average St. Lucian. The government wants to protect the banks. That's the argument the opposition is coming with. And I am saying to you, Madam President, that this is not the case. So if I can just move on to a few more constructive observations that were made. Before I do that, since Senator Stanislas is back, I wanted to make a couple notes in his presence because these were observations I made from his presentation. Aside from the sharks thing I addressed while he was out, I'm sure he'll get the message. He was saying that 1 year is not sufficient time, and that is between the time that your property, you are in default, and that the bank and you have to negotiate the consumer agreement. It must be very hot over there, but it's okay. I'll say it, however, his colleague will tell him. He may have a case. The longer the period you can negotiate, the better. But we are saying that the current legislation made provision for 6 months. And we have indicated that we want more time. So the 1 year is double the time that was in the current legislation. So that's a step in the right direction. And we believe that the public education issue that both himself and Senator Charles mentioned, we are in total agreement that there needs to be continuous public education. And I want to remind the Senate that it was agreed in the conversation in the lower chamber that that will continue. And the regulations will encapsulate or will incorporate that particular need. So, Madam President, if I may now look at the arguments presented, a lot more constructive, by Senator Charles, the independent senator. He did mention the issue of the court still having the ability to do certain things. And his Creole opening remarks were quite instructive. It's true. But he did not in any way call out anyone by any names. He just used a particular saying, which was quite in order. And while it is true that the court still has the ability to act on the defaulting people, but the opportunity is given to engage the client before the court moves in. So I think this legislation is at least giving people an opportunity to engage before that happens. And the provisions that he mentioned for the reporting was a very insightful observation. And I believe that the provisions can be made in the regulations for that to happen. As for the frequency of the reporting, I think that this is something that can be reconsidered, and especially to the Parliament. Madam President, the review, he mentioned he made a point about the review, and he said it says not more than 5 years, which is true. So I just want to give him a bit of assurance that not more than 5 years doesn't mean that we wait for 5. So I would hope that in the best spirit, that it would mean as often as is possible, or as frequent as is possible. So it could be within a year, within 2 years. And this is a new piece of legislation. So we have to take time to observe how it plays out, and then we can decide whether it is urgent that we return, or that it's working okay so we can wait. But not more than 5 would obviously mean it could be anything before. And he did mention another very important thing regarding the publication of the information, mentioning the Gazette, which is the official source. However, there is merit in exploring other sources through which the information and the education can be accessible. And that is true because we have, it's sad, but reading text and buying or subscribing to the Gazette and reading is not something that we can say we are the best in the world doing. I wish St. Lucians we would read more, including some of our colleague politicians. But if this can be taken to the level of social media, to the electronic media, and other sources or other medium, or other media that people access, the public education drive would be more effective. So I take that as a very, worthy and appropriate observation that we can consider. But I am very confident that because the bill is in its early stages in terms of implementation, that these can be considered. So, Madam President, before I close, I just want to remind everyone in this chamber that the purpose for which we came here today has not been derailed and is very clear. The purpose for which we came in today is to give St. Lucians an opportunity when they run into problems to protect them and to also not be irresponsible and give the lender a certain level of assurance and protection. That's what we came here to. And no matter what the opposition or anyone else tries to do in this discussion, I want to bring us back to that particular focus and say that this insolvency bill was brought to this House for that purpose. And I believe, based on the discussions we have had in both chambers, St. Lucians and anyone following this debate would have realized that this is what we have achieved. And so I thank everyone who have contributed to it, particularly the AG chambers and all other stakeholders who took part in the consultation, Chamber of Commerce and Consumer Association, and everyone else, the bankers, as well as ordinary St. Lucians who benefited from the consultation and the education, that we will see the benefit of that piece of legislation to protect both our average St. Lucian lenders and our borrowers and banks and lenders. I thank you, Madam President.
Senators, the question is that the insolvency bill be read a second time. I now put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
An act to provide for the appointment of a supervisor of bankruptcy and insolvency and a government trustee, licensing of trustees, bankruptcy orders, assignments, administration of estates, international solvencies, the regulation of corporate and individual insolvencies, the rehabilitation of an insolvent debtor, and for related matters.
Clause 2.
Interpretation.
Clause 2 stands part of the bill. Aye. Clause 3.
Application and non-application of this act.
Clause 3 stands part of the bill.
Aye.
Clause 4.
Conflict of laws.
Clause 4 stands part of the bill.
Aye.
Clause 5.
Act binds the Crown.
Clause 5 stands part of the bill.
Aye.
Part 1, clauses 6 to 15.
Administration.
Madam President,
Yes, yeah.
if I may propose the following changes to Clause 6, Part 1. Clause 6 should become, we propose it becomes Clause 6.1.
Page, please.
And that is on page 58.
Okay. So, Senators, page 58, please
Clause
proceed.
6 becomes Clause 6.1, and a new Clause 6.2 should be inserted.
Which is from page 270.
So we could now reference page 270, Clause 4262. So we insert a new Clause 6.2 on that page.
Okay. Are we on the same page, Senators? Okay, let's go through. Page 58, Clause 6.
Becomes Clause 6.1.
It becomes Clause 6.1.
Yes.
And then there's Clause 6, a new clause will be inserted here. It is,
On
and
page
it's
270.
taken from page 270
Yes.
and transferred. That's Clause 426.2 on page 270 now is now taken over and becomes Clause 6.2.
Correct.
Okay? Are we on the same page? Okay. Let's proceed. So, that's it. Part 1, clauses 6 to 15 stands part of the bill. Yes, Senator Charles.
Madam, hold on, huh?
There is a correction on page
We have a,
38
Clause 10.
to change the year to 2024 instead of 2023.
Yes, correct. Page 62, Part 1.
Clause 10.
Clause 10, yes, becomes Clause 10.1.
Yes. So on page 62, let's get to page 62.
Yeah.
Clause 10 becomes clause 10.1.
Yeah. And then you.
And then a new clause,
10.2 is inserted.
10.2 is inserted, and
Again,
from the
taken
same
from
page.
Page 460. 426 to
yes.
Page 270.
Section
From page 270,
270,
clause 426 2B,
Right.
it's now transferred to
Clause
page 62 and becomes
Clause
clause 10.2.
Yeah.
Are we on
Thank you.
there? All there?
Thank you. Yes, correct.
Okay. So repeat, part 1, clauses 6 to 15 stands part of the bill. Part 2, clauses 16 to 33.
Licensing of trustee.
Part 2, clauses 16 to 33 stands part of the bill. Part 3, clauses 34 to 56.
Assignment and bankruptcy order.
Part 3, clauses 34 to 55 stands part of the bill. Part 5, clauses 56 to 72.
Plus part 4, madam, that's part 4.
Plus 4, I beg your pardon. Part 4, clauses 56 to 172.
Proposal.
Part 4, clauses 56 to 172 stands part of the bill. Part 5, clauses 173 to 207.
173. Effect of bankruptcy on the property of the bankrupt.
Part 5, clauses 173 to 207 stands part of the bill. Part 6,
Administration.
clauses,
Oh, sorry. ma'am.
clauses 208 to 276.
Administration of estates.
Madam President,
Yes.
if we may, propose the following in clause 208, page 158, in part 6.
Page 158, everybody.
In clause 208(1)(b), we would need to change the number of days from 10 to 30 days.
Okay.
And also, page 159, the next page, clause 287.
The
And at
bottom of the page.
287, the next page. If we look at the end of subclause 7,
The fourth line.
in the fourth line, there are specific words we need to insert there, and that should be or in the Gazette or both, after the word St. Lucia.
Repeat, please, Senator. Read
So
up.
I repeat, if we can take it from the top, clause 208(1)(b), we change 10 days to 30 days. That's on page 158.
Yes.
And on page 159, we go to clause 287. And 287, just before, that's in subsection 7 at the bottom of the page, just before the word, after St. Lucia, we insert or we add the words or in the
So
Gazette.
we
or
remove the full stop.
Yes, we
Okay.
remove the full stop and add or in the Gazette or both. So
Or.
the sentence will end with that phrase.
Okay. So I think we are part 6, part 7? Madam Clerk, we were part 6 or part 7?
Part 6.
Part 6.
Part 6, right. Thank you. Part 6, clauses 208 to 276 stands part of the bill. Part 7, clauses 277 to 307.
Bankrupt.
Part 7, clauses 277 to 307 stands part of the bill. Part 8, clauses 308 to 352.
Enforcement.
Part 8, clauses 308 to 352 stands part of the bill.
Madam, yeah, sorry.
We
My
back up?
apologies. Trustee. Madam, you want to do that again?
Pardon?
Yeah, 308. Part 8, 308 is trustee. Sorry, I said enforcement. But it's trustee. My apologies.
That's what page, Madam Clerk?
32. We're going to page 33 now. Part there.
Page 23.
Section, yeah. Page 33. Yeah, we're going to part here. No, we're going in the front. Yeah, we're in the front because we're doing the clauses. So it's page, yeah, it's page, we're going to page 30, yeah. Part 8 is trustee, but I said enforcement, so I made an error.
Okay.
Yes, you get it?
I think I
You
got
with
a
me
little
now?
lost. So let's back up a
You
bit.
want me to come? Let me.
Yes, I am trying to follow where the error happened.
Okay, no, you're all the way there. We remember over here. So when you call 308 to what I said enforcement, but it should have been trustee.
Ah.
So,
So I read my part 8. Is it part 8? I go back to part 8. Part
Yes.
8, clauses 308 to 352.
Trustee.
Part 8, clauses 308 to 352 stands part of the bill. Part 9, clauses 353 to 361.
Enforcement.
Part 9, clauses 353 to 361 stands part of the bill. Part 10, clauses 362 to 368.
Interim receiver.
Part 10, clauses 362 to 368 stands part of the bill. Part 11, clauses 369 to 379.
Secured creditor.
Part 11, clauses 369 to 379 stands part of the bill. Part 12, clauses 380 to 397.
Court and procedure.
Part 12, clauses 380 to 397 stands part of the bill. Hold a second. Senator Charles?
Now, seeing my copy has a second part 11, perhaps I have a different version.
Okay, I'll look at it. I'll take a look at it. Give us a-
Is that an error on your document then?
Yes.
Okay, all right. So we proceed.
Yeah.
Part
B1.
12,
Yeah.
clauses 380 to 397 stands part of the bill. Part 13, clauses 398 to 414.
International insolvencies.
Part 13, clauses 398 to 414 stands part of the bill. Part 14, clauses 415 to 426.
Miscellaneous.
Madam President,
Yes.
under that part 67, part 14, page 267, under miscellaneous, we take a look at clause 419 on the rules of court.
267.
So we need to do the following: delete the semicolon at subsection 2A, part 5, page 267, and replace with a full stop. So that's punctuation correction there.
So we delete the line section B.
Yes, and after that, we also need to delete the entire section B.
Yes.
That reads, must not extend the jurisdiction of the court. That section needs to be deleted in its entirety.
Yes. And a full stop.
Okay.
And a full stop after.
After proceedings. Okay. Part 14, clauses 415, 415 to 426 stands part of the bill. Schedule 1.
Qualification of a trustee.
Schedule 1 stands part of the bill. Schedule 2.
Property priority of payment.
Schedule 2 stands part of the bill. Clause 1.
Short title and commencement.
Madam President, we have a slight amendment here in terms of the year. It says 2023, it should be 2024, so we change 2023 to 2024.
Page?
That's page 38.
Page 38.
Under clause 1.
Okay. Page 38 under clause 1, it should be year,
The year should be
2024. Okay. Clause 1 stands part of the bill. Senators, the question is that the committee rises and the bill be reported. I now put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it. Senators, I beg to report that the insolvency bill went through committee stage without amendments. Honorable Leader of Government Business.
Madam President, I move that the report of the committee be adopted and that the bill be read a third time and passed.
Senators, the question is that the report of the committee be adopted and that the insolvency bill be read a third time and passed. I now put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
Be it enacted by the King's Most Excellent Majesty, by and with the advice and consent of the House of Assembly and the Senate of St. Lucia, and by the authority of the same as follows. This act may be cited as the Insolvency Act 2024.
Honorable Leader of Government Business.
Madam President, I move that the Senate stand suspended until 2:40 for 1 hour, please. 2:40, please, p.m.
Do we proceed since Deputy is here?
Well,
maybe you have to. Do we want to take?
If I may withdraw the request.
Yes. Before I pose the question, I just want to acknowledge the presence of our St. Lucia's representative to Miss Universe pageant this year, Miss Kai Fauché. And so she has come to have a brief word with us as her candidacy is focused a little bit on climate change, sustainable development, and we are members of the ICCF, Conservation Federation. So during the lunch break, we shall have a brief conversation. So welcome, and Mr. Vitalis as well. So I pose the question. Senators, the question is that the sitting of the Senate be suspended until 2:40 p.m. As many as that opinion say aye. Aye. As many of our contrary opinions say no. I think the ayes have it. The ayes have it. Sitting adjourned suspended until 2:40.
nous venons au bout de session, ça c'est session qui commence bon matin en Sénat là, et côté yon bill, ça y est calculé insolvency. Et insolvency a voulu dire en loi qui le gouvernement a commencé et bien mettre dehors pour bien les gens qui prêtent l'argent en chance, les gens qui prêtent avec les gens qui a baillé l'argent en chance pour avant de saisir propriétaire pour ça ranger bagala en première manière avec la loi ça là comme il était discuté en cas constitué avec Jodia il semble qu'il y a une chaque discussion puisque nous c'est différents membres Sénat là qui participent nous tenir discussion trois c'est membres Sénat là ça c'est face à le gouvernement avec aussi tous les deux en face à l'opposition je participe aujourd'hui avec aussi un sénateur indépendant sénateur Charles participé à en discussion chaque monde partait quoi qui prend autant de temps budget.
Yes, it did go on much longer than we anticipated. That's because there was a full contribution from both members on the opposite side, as Senator Stanislas and Senator Dominic Fede, and there were contributions also from senators on the government side, Senator Alison Shaw, and of course the leader of government business who presented the bill. There was a lot of course, interruptions and debate and cross references, but the opposition's stance on the bill was that they felt, particularly the leader of opposition, felt that it favored the banks and it was really against the people. He described the bill as inhumane and draconian and egregious. And I think one of the primary reasons why he cited that, he was saying that, people would lose the house without any recourse of going to the courts. But of course that was refuted in the bill itself. It was cited by the leader of government business and other government senators. But all in all, it was a long debate, and the leader of government business, Senator Gideon Ferdinand, he again showed that the bill was presented checks and balances both to the borrower and the lender, and that it was an opportunity for both sides, the borrower and lender, the banks and the consumer, to come together in case where people are unable to pay the debt, that the bill allowed for some kind of discussion. And of course there were certain amendments and certain suggestions on the bill, and I think one of the suggestions, which I think was agreed upon by both sides, was that there's a need for public education on the provisions of the bill for everyone. So, as we said, the Senate has adjourned and will return here at what time, Mike?
At 10:30,
Okay, at 2:30 we return here for a continuation of today's Senate hearing.